Good day and welcome everyone. On behalf of Gibney, Anthony & Flaherty, I want to thank you for joining us today for a discussion about the complex world of PERM labor certifications. My name is Rosanna Fox. I'm a senior attorney in Gibney's Immigration Practice Group. If you're not familiar with our firm, Gibney is a full-service commercial law firm with offices in New York and San Francisco. In addition to immigration, we also provide services in the area of corporate law, intellectual property, tax, estate planning, and real estate, among others. We have extensive experience representing clients ranging from large multinational organizations to small startup companies across the industries, including the financial sector, technology, e-commerce, public relations, marketing, and biotechnology, to name just a few. Our immigration practice group focuses primarily on business immigration with an emphasis on institutional compliance as we help our clients navigate the tumultuous waters of immigration law. And if you ever had exposure to immigration matters, you will likely agree that few things are less predictable than PERM. We hope that our seminar today will provide useful insights into this very complex and intuitive process. I am very fortunate to be joined today by my colleagues, Monica Kim and Kira Lobreglio. Both Monica and Kira are senior attorneys in Gibney's Immigration Practice Group with extensive experience in PERM labor certification applications. Monica practices out of our San Francisco office, while Kira and I are here in New York. So before I turn the discussion over to Monica and Kira, I would like to set the stage, so to speak, by providing the context for the PERM applications. When we talk about PERM applications, we're really talking about green cards. The PERM application is a prerequisite to a particular type of a green card application, and therefore it would not arise in the context of a temporary work visa filing. Now, green card is shorthand for lawful permanent resident status, or LPR. And LPR status confers unlimited, unrestricted right to live and work in the United States. There are four general paths to LPR status: through employment, through family, by winning a green card number in a diversity lottery, and by seeking asylum or refugee status. PERM applications arise in the context of employment-based green cards, and particularly in the context of second and third employment-based preference category, also called EB2 and EB3, where EB stands for employment-based. You may know that there are 5 employment-based categories in all, each category with its own special eligibility criteria. EB2 and EB3 categories are by far the most popular because foreign nationals meet the eligibility criteria for these categories more so than the other 3 categories. So let's look at the eligibility criteria and differences between EB2 and EB3. First of all, to apply for a green card under these categories, the foreign national requires employer sponsorship, so the employee cannot self-sponsor. And by the way, you can see on the slides there, I included that employer participation is also required. And I did that to highlight a point that sponsorship in this process is anything but passive. The employer, and that typically means the manager or the HR representative, or both in some instances, will need to be actively involved in the process from start to finish, which in turn usually means a substantial time commitment. So going back to the eligibility criteria for EB2 and EB3, eligibility under these categories depends on the minimum requirements for the position for which the foreign national employee is being sponsored. So again, this doesn't really focus so much on the qualifications of the employee, but more so on the position for which they're being sponsored. And Monica will talk about that in more detail. You can see on the slide that EB2 is available when the foreign national is being sponsored for a position that requires at minimum an advanced degree. An advanced degree is typically means a master's degree or higher, but also as an alternative, you can use a bachelor's degree coupled with at minimum 5 years of progressive post-baccalaureate experience. EB3 is available to everyone else, which includes skilled workers, where the position requires at least 2 years of work experience, professionals, where the position requires at least a bachelor's degree, and unskilled, the so-called other workers, where the position requires less than 2 years of work experience, but the position is not seasonal or temporary in nature. So that's the legal distinction between these 2 categories. From a practical standpoint, a major distinction is in the processing times, and namely how long it takes to complete the green card process for a foreign national under EB2 versus EB3 process. There are far more foreign nationals applying under the EB3 category than EB2, and as a result, it typically takes much longer to complete the green card process for applicants in the EB3 preference category. And depending on the country of birth, some foreign nationals must wait 10 or 15 years before completing the entire process. So when we talk about the green card process for EB2 and EB3 and how long it may take to complete, what are we talking about? We're talking about three separate filings. The first of the filings is the PERM labor certification application, which is filed by the employer with the Department of Labor, and this is the focus of our discussion today. The second step is the I-140 immigrant petition, which is filed also by the employer, but with the U.S. Citizenship and Immigration Services. And the last step is the actual green card application, and that is the I-485 adjustment of status application. It is filed by the foreign national. His dependent family members are also eligible to apply, and that application is filed with the Immigration Service. And so while today we're talking about specifically the PERM application, we cannot really discuss it in a vacuum. The PERM application defines the trajectory for the entire green card process. And so to ensure success of the entire case, it is critical that we consider the impact of decisions that we make at the PERM stage and understand what that means for the subsequent two stages. And this will be examined closely by Monica and Kira. So what is PERM? PERM labor certification application is an attestation-based electronic filing by the employer with the Department of Labor. And by filing the PERM application, the employer is essentially asking the Department of Labor to certify that there's a shortage of minimally qualified U.S. workers willing and available to perform in a particular role. And this is a mouthful, and Kira and Monica will sort of elaborate on these requirements in much more detail. At the same time, the employer, by filing the PERM application on behalf of a particular employee, is expressing an intent to employ this foreign national in the specific position at the time the foreign national receives a green card. So PERM applications are actually forward-looking. The foreign national does not need to be employed in the specified position at the time of filing of the PERM application, and in fact, the foreign national does not need to be employed by the sponsoring employer at all, or even be physically present in the United States. The prerequisite to filing the PERM application is a labor market test, which is a bona fide recruitment campaign. And that is necessary so that the employer could make a determination whether or not there are, in fact, minimally qualified, willing, and available U.S. workers. Finally, the employer is required to examine any layoffs it may have had within 6 months prior to the filing date of the application to see whether any of the laid-off U.S. workers could possibly perform in a job. So because PERM applications are tied to the availability of U.S. workers to perform a specific role, these applications are position-specific, and that means they're employer-specific, they're location-specific, and specific to the job opportunities. And you will see in a minute why this limitation could be problematic. And one last point I would like to make is that since PERM applications are attestation-based and the employer does not submit any supporting documentation at the time of the filing, the Department of Labor may come back and audit the case. And there are two types of audits. There are targeted audits, which typically occur when the Department of Labor identifies a particular issue with the case. And there are also random audits, which are really designed sort of a fraud prevention mechanism where the Department of Labor wants to ensure that the employer completed all the steps that are required of them. And so while we generally try to take care to address any possible red flags as we strategize the case, we certainly cannot do anything to avoid a random audit. And according to the Department of Labor latest statistics, the audit rate nationwide is about 1 in 3. That tends to vary by clients. Some of my clients have an almost 100% audit rate, while others have close to 0. There's really no rhyme or reason for that, but my approach to these cases is that we treat every case with the assumption that it will be selected for an audit. So now I would like to turn the discussion over to Monica, who will share some strategies and considerations that arise in what we like to call the pre-recruitment stage of the PERM process. And that typically includes position drafting, verification of employees' qualifications, and preventing wage determinations. Then Kira will take us through the pre-filing stage, which includes the labor market test. And then we will wrap up with a discussion of post-filing considerations, which include audits. Monica?
Great. Thanks, Rosanna, for the overview. So what we'll do now is we're going to spend the rest of the seminar talking about really the nuts and bolts of preparing a strong application and the recruitment process. And I know that a lot of people can be wary of the PERM process, but hopefully by the end you'll see that it's really not so bad. So during her introduction, Rosanna talked a little bit about the Department of Labor, and I just wanted to start out by talking a little bit about why the Department of Labor is involved at all and why we have to go through this process. The Department of Labor's #1 job is to protect U.S. workers and to make sure that we're not displacing any U.S. workers, which includes U.S. citizens, permanent residents, and certain asylees. So we're testing the labor market again to show that we're not displacing any of these U.S. workers. And again, the whole point is to find out that there are no qualified, willing, and available U.S. workers to fill this role. To the Department of Labor, your foreign national applicant, the person that you're filing the PERM application on behalf of, he or she is a temporary worker in the Department of Labor's eyes. They are here on a temporary work visa, and in theory, that person would return to their home country once their temporary visa expires. The way they see it then is that you have an open position. You have a temp worker filling this role right now, and you need to find a quote-unquote permanent worker. So the Department of Labor has created this PERM process, the test of the labor market, and they really their goal is to make the process reflect your typical hiring and recruitment process, but the truth is that to really follow the Department of Labor regulations, the process is likely to be quite different from how you would normally recruit for an open position. And this includes how we're going to describe the position, how we will recruit for the position, and ultimately how the candidates who apply are vetted. So there are a lot of things about the PERM process that are not entirely intuitive. It can be a very unforgiving process. The Department of Labor is really looking for, they're looking for perfect applications. And as you will see, it's a long preparation time with often long processing times. So the first thing we're going to look at is PERM position drafting. We're looking at the position description, which is the actual text that will form the basis of all of the ads, the recruitment that will run during the test of the labor market. In the real world, you would be preparing a position description or a job requisition that you'd be trying to draw the most qualified applicants. And in the PERM world, the ads are looking to draw applicants who are minimally qualified. This is part of the PERM, of the goals of the PERM. So then what goes into the position description? So based on information that we're going to gather from the company, from the hiring manager and the foreign national applicant, and then after carefully considering the Department of Labor requirements and limitations, the ad typically contains some basics, the employer name, the position location, and the job title, and then 3 very crucial components: the duties of the position, the education and experience requirements, and then what we call the special requirements. Now, a few things to consider in the PERM context that you would not necessarily be considering in a typical recruitment context. And that's that the education, experience, and any special skills or requirements, with very limited exceptions, these things must have been gained by your foreign national employee prior to working for the sponsoring employer. So that's prior to joining your company. The requirements also typically cannot exceed the qualifications possessed by other employees in the same or a similar position. And then in the case of an audit, which Rosanna mentioned this situation with the audits, if there's an audit, we may have to justify the requirements to the Department of Labor and show them that the requirements as we've set forth meet a business necessity for your position and aren't otherwise unduly restrictive. So the position description is really, we're going to start first with the job duties. Drafting the job duties requires a little bit of a balancing act. When describing the job duties, we want to focus on, we really want to nail it down to about the 8 or 10 main day-to-day core job duties or tasks that are performed by your foreign national. We want to keep the description general enough so that we can assume that this individual will be performing the majority of the same duties by the time they get their green card. Because remember, the foreign national employee is considered to be a temp role right now, and we are recruiting again for that future, that permanent position role. So we want to avoid making the duties so specific right now that we're talking about, for example, a project-based duty for a project that's not going to exist 6 months from now. But on the other hand, we want to make sure that we're describing the duties with enough specificity that we're showing the level of sophistication that is required to complete the job duties. Because when we're evaluating applicants, when you get into the recruitment stage and applicants start applying, we're evaluating these applicants based on whether they can competently perform the job duties as we're describing them in this position description. So again, as a reminder, the PERM applications are for a specific foreign national at a specific employer, location, and position. And if any of that changes, it might impact the whole process. And that said, we are looking forward to the permanent position so we can anticipate these job changes. If you're reasonably certain that a job change or a significant promotion is in the near future, we can prepare this position description. We can outline the job duties for the future position. This is, again, the role that we expect them to have when the green card is approved. Similarly, if once we're into the PERM process and any changes occur with the duties, the location, or even the legal employing entity, if there's a reorg within your organization, we may need to evaluate and determine if there's an impact on the process at hand and whether any changes need to be made. So the next thing we consider are the education and experience requirements. How do you determine the requirements for the position? Generally, we're going to look at the actual minimum requirements for the role at your company. We're looking at the industry standard for similar positions, and we also consider the Department of Labor standards as well as your qualifications of your foreign national employee, the applicant for the PERM application. So the first thing we want to keep in mind is that in a PERM context, we can only require the actual minimum education and experience required for the role. So what's the minimum? For example, if you typically at your company require for a position a bachelor's degree or a master's degree and 3 to 5 years of experience, the minimum is the bachelor's degree, because that's the lowest degree that is acceptable, and 3 years of experience, the minimum number of years acceptable. We also want to look at the actual requirements. We don't just look at what you have written down as your official company description for a position. We look at what are your hiring practices. So the actual minimum requirements are what you would actually hire people with. So if on paper the requirement is bachelor's plus 3, but you typically hire people with bachelor's plus 2, your actual minimum requirement is the bachelor's plus 2.
So, Monica, let's say we look at a particular job and determine that the actual requirements for hiring into that role are bachelor's plus 5, but then when we look at the industry standard, or for instance, what your sponsored employee has in terms of qualifications, it turned out that they only have 3 years of experience. So maybe that's the standard, but perhaps a master's degree is often acceptable or required by other companies, or perhaps the master's degree is what your foreign national has. So what do we do with that?
So the PERM process does allow us to use alternate requirements. So we have an option in this particular scenario. We could downgrade, we could lower the requirements and require just a bachelor's degree and 3 years of experience. But that's going to put you into the EB3 category, that category that takes a little bit longer to get through the process. But we can actually do alternate requirements. So in this case, if the company requires a master's plus 3, we can then also accept a bachelor's plus 5, including the alternate requirement in the PERM position description. That keeps your actual minimum requirements in place and allows an alternate requirement, and in this scenario keeps the individual in the EB2 category. So in addition to your own company requirements, we're looking at the Department of Labor and the industry standards. So if, for example, the Department of Labor and a typical industry requirement for a position is bachelor's plus 3, but your actual minimum requirements are bachelor's plus 10, even if that is truly your actual minimum requirement, we need to be prepared to show the Department of Labor why in this particular situation 10 years is required where normal industry standard would only require 3 years. Then lastly, we cannot require more than what your foreign national employee had when he or she joined your company. And this is where we consider the individual's degree and the experience that they had. With regard to the degree, if they have a foreign degree, so anything that was obtained outside of the United States, we need to have it professionally evaluated to determine the U.S. equivalent. You know, sometimes the degree that your foreign national applicant thinks that they have, or the equivalency that might have been acceptable in the non-immigrant situation, might not be okay for PERM purposes. So it's always important at this step to reevaluate that, make sure we're working with a degree that's going to be acceptable in the PERM context. With regard to experience and skills, we generally cannot use experience or skills gained with the sponsoring employer. This is considered on-the-job training, and it's something that we would need to offer a U.S. worker. The exception is if we can demonstrate that the PERM position, the position we're recruiting for, is substantially different from prior positions that your foreign national held in your company. And this process requires doing an upfront detailed analysis of the job duties of each of the positions so that we can be prepared to show the Department of Labor that the job duties are more than 50% different. A good example that I like to give in this context is if someone joins your company as, say, an engineer, software engineer, and then 3 years later they move into the marketing department to market the products that they've been developing, this is a case where we would likely be able to use the experience gained with the sponsoring employer because it's related. They're now marketing the products that they were developing, but the day-to-day job duties are going to be substantially different. So next we're going to move to what we call the special requirements. This is really the section that, for me, I see this as being the most important section of our position description. This is where you have a chance to set your position apart from other similar positions, and it's where we can focus on what's unique about this role and what your employee brings to the role. It's not always difficult to find a U.S. applicant who meets the threshold education and experience requirements, but then they also need to meet all of these special skills requirements, or the special requirements. And what do we mean by this? The special requirements are typically objective, quantifiable skills, so not soft skills or people skills. And some examples can be tools, programming languages, or methodologies, or other specialized experience. The important thing to keep in mind here is that these skills are required for the position. These are the things that a manager requires of anyone in this role on day one in order to perform the job duties. The skills that the manager really is not going to be willing to compromise on. We can't use skills that are simply preferred or what I call the nice-to-have skills. These are actual requirements. And a few things to quickly point out. Foreign language requirements. This is brought up in more than half of the cases I work on. People want to include foreign language requirements. They're usually only going to be acceptable in a situation where a foreign language is inherent in the job, and that could be, for example, a translator, or a localization engineer. Those are places where, language is inherent in the job duties. And this is going to guarantee an audit. Rosanna will talk about this later, but this is really one of the flags. This will guarantee an audit. Your foreign national applicant almost certainly speaks a language other than English, and so the reason you're going to be audited is the Department of Labor wants to make sure that the language is really required for the position and not just a way of tailoring the requirements to meet the qualifications of your foreign national. Similarly, proprietary tools are generally unacceptable. The Department of Labor considers this an unfair advantage to somebody already working at the company, so unfair advantage to your foreign national. And while not a special skill, we do always want to make sure we are documenting travel requirements and disclosing this. Travel requirements can be seen a pro or a con. Department of Labor wants to make sure that anyone applying for the job has a full understanding of what they're getting themselves into. The catch with the special skills and the special requirements is that your foreign national employee must have had these skills, again, just like the experience and the education, before joining the company, and they need to be able to document that he or she had these skills before they joined the company. And that's where we move into what is typically employment verification letters or other documentation of the employee's qualifications. So in order for your foreign national to demonstrate that they're qualified for the position as we've just defined it, they will need to obtain documentation to demonstrate and prove their experience and skills. Many employees, when they join, they already have with them documents such as offer letters or leaving certificates, but these are alone usually insufficient. Documenting the qualifications is really a crucial part of the process. It can be difficult. Employees sometimes have to go back and ask employers that they haven't talked to in 10 years to get a letter verifying their job duties. So it can be awkward, time-consuming, sometimes very difficult, but it's requirement for the process to prove that your foreign national is qualified for the position. This step of obtaining the documentation is usually the responsibility of your foreign national. Managers and HR aren't usually going to be involved in this. But we do provide, in our cases, we provide a lot of assistance. We usually help them prepare the letters so that we can make sure that all the legal requirements are met in the letters. Then we just forward them on to the foreign national to obtain signatures. The typical requirements, what the USCIS, what the Immigration Service likes to see is they usually want the letter to be on company letterhead, include specific job duties and title, the job title, and the dates of the employment, and then of course the special skills that we're trying to prove that we noted in our position description. Occasionally, we do have to come back to the managers or to HR and request revisions of our position description, because if we can't document and prove that the foreign national met all those requirements, then we'll want to revise our job description and not include things that we can't prove.
So, Monica, it sounds like you're saying that if the foreign national employee is not able to get a letter that confirms all of the qualifications, then we can't include those requirements in the PERM position. But let's say you have a foreign national who qualifies for the PERM position based on just one employment, yet that employer is out of business, or maybe they have a policy against issuing detailed letters, so they just say, okay, well, we'll give you, a templated short letter, but we cannot include a job description. So what do we do in that instance?
This happens all the time. We see a lot of different situations. For example, companies that don't exist anymore, managers that are gone, like you said, HR departments that they say they're not going to provide the detailed letters that we need. The detailed letters, as I described, they're the so-called primary evidence. That's what the Immigration Service really wants to see. But they will accept secondary evidence, and that can be a combination of offer letters, severance letters, colleague letters, other written documentation to show employment. And we will work with the foreign national employee to gather the best combination of evidence. That said, the decision to accept or reject that secondary evidence is going to be completely up to the Immigration Service. So we always advise, as painful as it sometimes can be, it's always advisable to try to get that detailed letter directly from the company whenever possible. The last thing that I wanted to touch on before we finally get into the recruitment process is the prevailing wage request. This prevailing wage request is an interim application. It's another application. We file it electronically with the Department of Labor. It's a required step in the process, and it has to be completed really before the recruitment can start. The prevailing wage request serves two purposes. First, it allows the Department of Labor to verify the prevailing wage for the position in a geographic location of employment. It also allows the Department of Labor to classify or categorize the position into one of their broader occupational categories that we then use for conducting the recruitment and then later filing the I-140 immigrant visa petition. The Department of Labor have several wage levels, and more often than not, they slot people into the highest wage category. So from a practical side, we really need to consider these wages in advance during the drafting stage. And we focus on describing the core duties of the position so that we can explain to the Department of Labor clearly what this job entails, and then hopefully they can then assign the appropriate category.
Okay, so let's say we submit the prevailing wage request with the Department of Labor. We get our determination, but let's say the Department of Labor misclassifies the position, or maybe the wage is too high. What does that mean?
Well, it happens. This does happen. The Department of Labor does make errors. Their list of occupational categories is pretty limited. It doesn't always include a direct match to the position in question. So when errors do include, we have a few options. We can ask for reconsideration, which means we can provide the Department of Labor with more information and our argument for a different category or even a different wage level. Or we can modify the position description. We can change our description and hopefully give a better understanding to Department of Labor about the role, and then we just refile the request. The third option is to agree to pay the wage. So even if you get a wage that's higher than what your foreign national is making right now, we can agree to pay that wage. The PERM application, again, is we're looking at this, we're always looking forward into the future. What is the position that the foreign national is going to hold when they get their green card? And that includes the wage. We don't need to pay the prevailing wage until the green card is approved, and in some cases that could be years. So that it's going to be a case-by-case situation about how we'll handle what we would consider an error or a determination that we weren't expecting. And then in terms of timing with these prevailing wage requests, it usually takes about 6 to 8 weeks to issue the initial determination, and it would be another similar length of time in any refiling or reconsideration situation. And it's only after we get our final acceptable determination that we can start the recruitment process.
Okay, great. Well, thank you, Monica, for this overview. If I may pause here for just a second, we are getting questions online, which we're really glad to see. We will address those questions towards the end of the presentation. Before I turn this over to Kira, I just want to circle back to what was said earlier about the amount of effort and time it takes to work through the process. So look how much work we've done by now since commencing the process, probably months worth of work, where we have to, work on putting together, defining the job, identifying the job, figuring out our employees' qualifications, figuring out the minimum requirements for the position, working on securing the employment verification letters, ensuring degree equivalency, obtaining a prevailing wage determination. So literally months worth of hard work. And we are only now ready to begin the labor market test, which is really sort of the crucial part, the whole crux of this application. So, this again just illustrates the complexity of this process and also just gives you an idea of how long it can actually take to complete it. So another note here is that, before we actually start the recruitment process, now would be a good time for the employer to take a look at any layoffs that may have occurred recently to see whether or not there's an impact on the PERM application. Now, the layoff analysis is time sensitive, and so is the labor market test. And so because of the particular interplay between these two separate timelines, we have to be really careful because we don't want to commence the recruitment process and spend all these resources and time and money only to find out that, in fact, we're prohibited from filing. So, now would be really a perfect time for the employer to have a look at layoffs and decide whether or not it is appropriate to start the labor market test now, or perhaps postpone for a couple of weeks, or sometimes it's necessary to postpone for a few months. So let's assume there's no impact from layoffs. We have our employment verification letters and they meet all the Department of Labor criteria. We have our prevailing wage determination and, the salary is fine. So Kira, would you mind telling us what we do next? What are the requirements that are associated with this labor market test?
Sure. So now we're ready to begin recruitment, and as Rosanna said, we're a few months in, but we still have a few months to go. The recruitment campaign is going to take at least 2 months and at most 6 months, so we're not quite there yet. As my colleagues have mentioned, the U.S. labor market test is designed to determine whether there are qualified, willing, and available U.S. workers to fill the sponsored role. And also, as previously mentioned, the Department of Labor wants this process to mirror a normal recruitment campaign in the context of your business, but in reality, in a lot of ways, it doesn't. And that's because the process is governed by regulation, which requires a number of recruitment steps that have very specific timelines, content requirements, and applicant assessment guidelines, and mandates the maintenance of detailed recruitment efforts in a compliance file. So when we're running these campaigns, our goal is really to structure the recruitment campaign so that it is as closely as possible in keeping with your normal practice, while also complying with all of these Department of Labor mandates. So if your company generally works with an outside recruiter to run recruitment, the same would apply in the PERM context. Similarly, if you typically work internally with an HR representative to recruit for and assess candidates, that HR person would likely oversee the PERM recruitment campaign as well. What you can't do is have your lawyer run the recruitment campaign and assess the candidates for you, and you certainly can't have the sponsored foreign national participating in the recruitment and assessment of candidates. So let's talk a little bit about the mandatory postings and recruitment steps that will constitute the labor market test. So there are a number of mandatory postings that need to go up. The first is the hard copy worksite notice of filing, and that's going to be posted at the worksite of the sponsored position, and it's going to go up for 10 consecutive business days. The worksite posting is required so that workers at the location are given notice that there's a PERM application going on, and that posting needs to have some pretty specific contents, and you can see those listed up here on the slide. One of the key thing really is that notice language, giving the Department of Labor information and the address of the certifying officer, and that's really the key to giving those workers at the worksite notice that this PERM campaign is going on. The in-house media posting is going to be a mirror posting, the same as the hard copy worksite posting, if your company uses something like an intranet or an e-bulletin board to recruit for this type of position. So again, those are going to be 2 identical postings. The 10 consecutive business day requirement is, again, going to mirror your typical business day. Most companies are working, Monday through Friday, but if your company is a 7-day-a-week operation, then you would post 10 consecutive days, and you would just need to be able to document that to the Department of Labor, showing that your typical business operation is a 7-day-a-week operation. We have also a number of mandatory recruitment steps that need to take place within the PERM labor market test. The first being a job order placed with the state workforce agency. By regulation, this job order posting needs to run for 30 days, and it must contain the particular job details. The specific content requirements, though, vary from state to state. We are also looking at 2 Sunday newspaper ads. So the Sunday newspaper ads need to run in a newspaper of general circulation in the location of the intended employment. And again, it needs to state those key job details, the employer, the location, the job duties and requirements, and how an applicant can submit his or her materials. One thing to note, if we're recruiting for a professional position, and again, that's one requiring a bachelor's degree, one of these Sunday ads can be replaced with a print ad in a professional journal.
So, Kira, you're saying that that the newspaper ad has to be placed in a newspaper of general circulation in the area. So, for instance, if we're recruiting for a position that is located in New York City, we have different major newspapers here. I mean, we have the New York Post, we have the Daily News, we have the New York Times. So how do we select the appropriate newspaper where this ad should be placed to make sure that we're in compliance with the Department of Labor requirements?
Yeah, so again, we're going to want to try to mirror as closely as possible your general practice. So, we're in New York. New York Times is a big newspaper. That would be an appropriate choice. If you don't typically need to use the New York Times, and the New York Times certainly can get expensive, the New York Post would be appropriate. This is a good faith campaign, so any other appropriate, similarly sized, circulated newspaper would work. What we don't want to do, for example, in New York, if we don't want to use the New York Times, we wouldn't want to look at a very small newspaper circulated only in Queens, for example. So again, we just want to, mirror as closely as possible the employer's general practice and be operating in good faith. One thing to mention in terms of ads getting expensive, you can abbreviate. You don't have to have every last detail of the position in that newspaper ad. So we often truncate the list of duties, just making sure it's sufficient to apprise applicants of the actual job opportunity. Okay, so again, if we're talking about a PERM recruitment campaign for professional positions, the employer will also be required to choose three of the following recruitment steps. You can see them listed here on the slide. I won't read them all off. Again, the 3 methods chosen are going to try as best possible to mirror your normal recruitment practices. So if you typically advertise on your website, that would be a good option. Job search website, again, if you're advertising in a newspaper, you often have the option of also in connection with that newspaper ad, have the job posted on monster.com, for example. The posting periods and timelines are going to differ based on the particular type of advertisement, but again, we would work with you to try to have this taking place as closely as possible to your normal practices. So let's just go over an overview of the recruitment timelines. As I mentioned earlier, the statutory minimum for the PERM recruitment campaign is 60 days. The job order needs to run for 30 days. Once the job order is down, the employer must engage in what's called a quiet period, which is really a period during which no active recruitment is going on, but you are required to continue to accept and assess applications for the position. So 60 days is the minimum. 180 days is the maximum length of a recruitment campaign. Your recruitment will expire 180 days from the date of the first recruitment step. So once your recruitment expires, you can't file the PERM using that recruitment. So just something to keep in mind. Given that there are several moving pieces, as you can see, to this recruitment campaign, it's not always possible to start every piece of recruitment on the exact same day. Ideally, all of the recruitment will be up and running during the job order, the 30-day job order posting, but regardless of whether everything starts at the same time, we have to start counting the 180 days from the first method, and we need to calculate that 30-day quiet period after the last method finishes. So again, 60-day, 2 months minimum, or 180-day, 6 months maximum. So let's talk a little bit about assessing applicants as they come in. Just as a reminder, when we're talking about testing the U.S. labor market, we are only concerned with U.S. workers. So when you're looking at applications, if an individual is not a U.S. worker, meaning they're not a U.S. citizen, they're not an LPR, or some asylees or refugees, they don't actually form part of this applicant pool.
And Kira, how would you determine that normally?
Yeah, so some people will put on their resume that they're a U.S. citizen, or conversely that they're currently on an H-1B and require sponsorship. So that's on the face of the resume. Often companies will ask that as a pre-screen to an online application, and they're asking, will you require visa sponsorship now or in the future? So that's an easy way to tell if someone is or is not a U.S. worker.
So once you determine that a candidate is not in fact a U.S. worker, you don't need to do any further assessment. You can just disqualify them?
Exactly. They're not part of the U.S. labor market test for these purposes.
Okay.
So in assessing applications, employers are really encouraged to make a timely review of resumes as they come in, and are required to assess applicants against the PERM job requirements.
When would you normally recommend that the employer start reviewing resumes? You mentioned the quiet period on the last slide. So does the employer have to wait until we're in a quiet period to start reviewing resumes? So what's your recommendation there?
So really, applicants should be assessed, as I said, in a timely manner. You don't want to have a huge gap between when the application comes in and when someone is taking the first look at their credentials. There's no required period, but ideally, and it's not always possible to do it, in real time, but really, employers are encouraged to assess applicants, on a rolling basis as they're coming in. So again, you're assessing the applicants based on the PERM job requirements as outlined in all of this advertising material. If a candidate meets the core PERM requirements, meaning the education and the experience on the face of the resume, that applicant should be interviewed to determine if they have the special skills. As we had discussed earlier, the Department of Labor wants this assessment to mirror your normal recruiting practices, but again, the PERM labor market test is concerned with identifying a minimally qualified U.S. worker, whereas you're generally in a normal recruitment practice looking for the best qualified U.S. worker. So it's a little bit of a disconnect here. You know, we're looking at just the basic requirements, not if somebody is the best candidate to fill the role, but if they're minimally qualified to fill the role. So again, if a candidate meets the core requirements on the face of the resume, you're going to want to bring them in for an interview to assess their special skills and whether they meet those special requirements.
So, well, first of all, when you say bring them in for an interview, does that mean you have to physically meet with that person?
No.
Face-to-face?
So again, if your typical practice is to phone screen interviewees before you have them meet in person, that's perfectly acceptable.
Okay.
You don't have to meet with them in person.
Okay, so let's say you've reviewed the resume and determined that a particular candidate meets sort of the core education experience requirements and you would like to bring him in for an interview. You contact them, but then the candidate never responds. So what do you do? How do you proceed from there?
So that really goes to the availability of that worker. Again, this is a labor market test to determine whether there's a qualified, willing, and available U.S. worker for the role. So if you contact someone and they are never getting back to you, that person can be determined to be unavailable for the position. And again, you're just going to want to be able to document your efforts to contact that person and be able to show that they never responded to you.
Okay. Well, here's another sort of interesting scenario that comes up once in a while. What if during the interview, the employer realizes that the candidate is actually a great fit for another opening in the company? Can the employer hire that person for that other role?
Absolutely. If you encounter a candidate that is, perfect for another requisition that you currently have open, you can hire that person. However, in the context of this PERM campaign, you need to be able to document why that person is not qualified for the sponsored position. So again, going back to assessing that person against the job requirements, you're going to need to have your lawful job-related reasons for disqualifying this person from this specific position. So again, maybe they don't meet the education or experience outlined on the PERM, or during your interview you've determined that they don't have these specific skills necessary to perform this role.
Okay, but what happens if you after the interview, you ultimately cannot disqualify a candidate based on the education and experience and special skills that are outlined on the PERM Act? What does that mean?
So if you can't disqualify them based on the specifications outlined in the advertisement, you can talk to that person about salary if they are willing to accept the offered wage. If they're not, that is a valid reason for disqualification. If that person is unwilling to relocate, for example, there's no requirement that you pay for them to relocate. So if they're not going to come to your location, that's fine. If at the end of the day they'll accept the salary, they will relocate, they meet all of the specifications, then the labor market test has failed and you can't file the PERM. You found a qualified U.S. worker and you can't make that attestation that there are no qualified, willing, available U.S. workers. So let's say we have not found any qualified U.S. workers and we've finished our recruitment campaign. We want to get ready to file the application. So before we file the application, we just want to make sure that all of our compliance material is in order. Again, this is an attestation-based filing, and there is no documentation filed at the time of submission of the application. However, should the case be audited, you will want to make sure your compliance file is complete. So this is a good time to just do a quick look at your documentation and make sure it's in order. So before filing, you just want to make sure you have a copy of the prevailing wage determination, all of your recruitment evidence, so all the documentation of your Sunday newspaper ads, your website postings, your worksite postings, showing what newspaper was in, what dates it was up, etc. You're going to need a recruitment report, basically detailing all of your recruitment efforts and the results. So how many people applied, why they weren't qualified, etc. Again, you're going to want to make sure you have all of your communication with applicants documented. So going back to our unresponsive candidate, you're going to want to make sure you have all of your emails in there to be able to show that that person was disqualified because they never responded. And then finally, going back to something that Monica had mentioned earlier, you're going to want to have all of your business necessity documentation showing why the specific education experience and skills are required within the context of your company. So once your compliance file is complete, we can move to filing the application.
Okay, so thank you, Kira, for that overview. And again, just circling back to the timeline, we have, after having spent several months on preparing, strategizing our case, we then also spent at least 2 months, right, at least 60 days on the recruitment process. Typically, I think the vast majority of PERM application processes, the recruitment processes take longer. So on average, I would say they take about 3 to 4 months, right? Would you agree? So, we're now well into, the 6-month mark, possibly longer, and we're only now getting close to the filing. Or maybe able to file the application. Again, prior to the filing, it would be a good time for the employer to have a look at any recent layoffs to see whether or not there's any impact. Assuming there's no impact, as Kira said, we'll be filing the application. It's an electronic filing. Typically, we as counsel handle the submission in our office. We do typically have the employer and the sponsored for national review the application prior to submission. Now, in terms of the processing times, if anything with, any sort of review involving a government agency, these tend to fluctuate. The current processing times for straight-through processing are about 4 to 5 months. After this initial 4 to 5 month period, we would normally find out if the case has been approved or if it has been audited. And if the case has in fact been selected for an audit, then we're looking at another 12 months before we have the final decision. Now, an interesting thing about audits is that unfortunately, we're given a very short deadline to submit a response. And these audits tend to be quite comprehensive, such that, we need to spend quite a bit of time putting together our response. And typically, in responding to the audit, the employer is required to submit a detailed recruitment report that analyzes the qualifications of each applicant in great detail. The employer is often required to submit a business necessity justification that Monica talked about, and that also often requires quite a bit of work. So there's a lot of pressure once we get to this stage to prepare a complete response, and unfortunately, the PERM application process is quite unforgiving, so that, any error, however tiny, can ultimately result in a denial. So it's really important to be prepared for this audit as much as possible, or rather be prepared for the possibility of an audit in advance of the filing. And this is why there's so much upfront legwork involved in putting together this application. We've completed the formal part of this presentation. We do have quite a few questions here. Unfortunately, we may have time only for about 3 or 4 questions, but we will try to respond by email to those questions that we're not able to address. Also, as far as the seminar, a recording will be available on GIVNY website. And also the PowerPoint presentation, I believe, is available through a link, I'm told, on the screen. There should be a link to the PowerPoint materials. So as far as our questions, there's one question relating to the minimum requirements. Monica, perhaps you can take this question. The question is, in your opinion, what is the recommended amount of special requirements?
Sure. So there's no rule about how many you can or can't have. In fact, you don't have to have any. It's just a way, as I said, to distinguish your position from other cases and get you beyond just those threshold education and experience requirements. I would say the recommended amount is, we generally shoot for somewhere between maybe 5 and 8, somewhere around there. If you get much more than that, it just becomes cumbersome at the interview process anyway, but it also starts to raise a red flag with the Department of Labor. If you have this laundry list of special requirements, they're going to wonder if these are really required things for your position, and if you are tailoring the application to your foreign national, and that is something that's not allowed. We can't tailor this position. Again, we're looking for the minimum requirements for the position and not trying to create a position that only your foreign national candidate could ever qualify for.
Mm-hmm. Yeah, I would agree with that. I think I've definitely had cases where we had, about 5 special skills listed, but I've also had cases when we only had 1 or 2. I think that really just depends on the nature of the position and how sophisticated that role is. If you're talking about a highly technical IT role, it's entirely possible to have, a list of 20 technical skills that are required for the role as a minimum. If you're talking about a different type of role, then the requirements may look entirely different. So I think that really depends on the case, but as Monica noted, on average, probably 5 looks less suspicious and kind of less, it doesn't generate any red flags with the Department of Labor. There's also a question relating to recruitment, and maybe Kira, you could take this. Is there a risk if recruitment is conducted at the same time as the prevailing wage request is submitted? So I understand that means that do you have to wait for the prevailing wage determination to commence your recruitment, and what are the risks?
Yeah, so you don't have to wait to start recruitment, but there are some risks inherent in that strategy. The main risk being if you get a prevailing wage that is significantly higher than you anticipated, you might have an issue there. As we discussed, some of the postings need to contain the salary, so if you have a prevailing wage that's a salary higher than what you posted, you're going to need to repost. Also, the prevailing wage determination is only going to be valid for a specified period, and that period is going to sort of dictate when you need to recruit and file. So, it can be done. It just means that you're going to need to be a little bit more careful about your timelines when you are recruiting and moving to the filing stage. So it can be done, but it's not without risk.
Thank you, Kira. There's another interesting question, and it goes, PERM recruitment requires applicant to be willing and able. If an applicant says they're unable to start working for several months, can they be negated? What is a good standard to use for time frame an applicant must be willing to start position? So I don't think there's a black and white answer to this question. My recommendation would be that the ability of the candidate to start employment on a given date really should not be a factor in evaluating their qualifications and their availability. I think the issue of availability really has to do with whether that candidate is available to commence the position. And since the PERM application is forward-looking and it's an offer of prospective employment, we can sort of require a candidate to commence employment immediately. I think the availability issue really goes to whether or not a candidate who now understands all the terms and conditions of the given position is available, or rather, is not otherwise occupied, engaged in another role to commence that role if given the opportunity. So this would, the availability reason for disqualification would really apply in the context of a candidate who, replies, "Thank you for contacting me, but I had actually just accepted another position with the employer." Now, again, I don't think that's, a yes or no answer. I think that's sort of, this is going to be probably a varied answer by the practitioner, but I would probably just be inclined to say that we need to find other reasons for why this candidate may be disqualified that are more closely connected to the position itself. I don't care, Monica, do you care to weigh in on this?
I would tend to agree.
Okay. I think we have time for one more question. Let's see. Has your firm had success with providing an independent survey, such as Radford, for prevailing wage?
I can take that. We have. It is, it's sort of 50-50. It depends really on, we've had success, and we've also had the Department of Labor completely reject those requests. It's going to depend on a couple of things. What is the nature of the position? What industry is the position in? What kind of Radford data do you have? There's not just one generic Radford source. It's going to depend on whether your third-party source of wage information meets Department of Labor criteria for showing the proper wage. And that includes, the criteria is how many companies were surveyed, what's the industry, how many employees are involved. So there's a number of factors that go into that. So the short answer is yes, we do have success with third-party independent wage surveys, but it's not always a guarantee.
Thank you, Monica. Okay, well, we're out of time, unfortunately. Thank you so much again for joining us for today's webinar. We do hope that you join us for future presentations. Our contact information is listed on the last slide. If you have any follow-up questions, feel free to contact us by email. Thanks again, and enjoy the rest of your day.